Okay, everybody, we got a small group here today. So it's more intimate, and please feel free to just jump in with questions you may have. Anything specific as to you, we can talk about as well as we go through all this. Should I kick the door? Yeah, we can kick it door. It doesn't matter. Do you want to be spread out like this, or do you all want to go on one side and make it more intimate? What do you think? I'll leave it up to you.
That's fine. People are going to keep popping in.
You think? Okay.
Yeah.
Well, let's get started because we're limited time. I'll just start by introducing myself. I'm Stacie Hausner. I've been a mediator for the last 20 years. I've mediated close to 1,500 disputes at this point. I've been with ADR Services. We have a booth out there, the wonderful ADR Services, for the last 7 years, which I have loved. And I mediate all types of disputes, so I'm a generalist. I also teach mediation at Pepperdine Law School. I've been teaching there the last 7 years. So I think I've taught like 35 classes. Now my students are actually beginning to mediate with me, which is so fun. I mean, they know all my tricks, but they are, I'm having a great time with that. And I have a master's in dispute resolution, so I also train mediators. I train like Central District Court panel down in Los Angeles and the LA County Bar and the State Bar, and do a lot of trainings. Most judges and lawyers come through our program at Straus. I don't know if you've heard of it, and so I do some of that training as well for a program called Mediating the Litigated Case. So I do all things mediation all the time, every day. I love it so much. So in doing that, I have learned a lot. Okay, fantastic, come on. I have learned a lot about what strategies people can use to optimize the outcome for someone. I think because 95% of our cases settle, I think by getting some of these strategies and things to think about as you're approaching a mediation and mediating, you really can help your clients out and optimize the outcome. So that's what we're here to talk about today. I'll share some of my insights on that. Jump in with questions. This is such an intimate environment, so we can focus on something or pass by something that you're uninterested in. Okay, so today we're going to cover 3 different areas. The first is going to be before the mediation. Now, we're going to spend some real time in this because if you talk to any mediator and ask them what's the most important thing to enhance your client's outcomes, they're going to say how well you're prepared, what you've done before you even walked in the door that day. So we're going to spend a little time on that so that you can best position your clients. Then we're going to talk about what happens in a mediation. How should you approach the negotiation? What should you tell your mediator, not tell your mediator? I'll give you some insight on what we're doing and what we're thinking about and how we're using information. So then when you're in the mediation, you can also optimize the outcome. And then finally, we'll talk about after the mediation. What can you do to protect your client when you settle? What language should you make sure is in the settlement agreement? And when you don't settle, what can you do so that you can be set up for a successful second session or use a mediator's proposal or something like that to your advantage. Okay, so we're going to hit all 3 areas. So let's jump right in. First thing I just want to say briefly is your approach to mediation. So some lawyers come in and they treat it like they would in court. They're very positional. They do what we were taught in law school. They're zealous advocates. They discount everything the other side says and they start yelling to me about the importance of their case. I don't think that's the best approach. That's what we call a competitive negotiator, and they're not really looking at the game to the other side. I think you're much better off coming into a mediation as a problem solver and say, look, I'm here today to evaluate my case, look at the risks and the costs and the strengths and the weaknesses, and decide what's a good settlement. So I think the approach matters here, and I think you should just come in with this general frame of mind. Before I say key is preparation, that's what's really key, but preparation is the key, so we're going to look at that. First thing is, it seems obvious, know your case. So oftentimes lawyers are very, very busy and they have associates work up the case and they don't know what the evidence says, shows, they don't know what happened in the depot, they don't know what their client's talking about, they may not even know what like the alternative to a settlement would look like for their client or the cost. Know your case. I mean, information is power. They do social science studies, and the more information you have, the better you're going to be. So when I come into your room and I say, look, the defense is making a big deal about this, you can say, yeah, but did they read the depo? Or did they see this witness is saying this? Or did they take a look at this video? If you have that pushback, that's very beneficial to getting a positive outcome. Timing of mediation matters as well. So do you want to come in early? Early, you don't know what's going to happen, what the discovery is going to show. So that might be a good thing or that might be a bad thing. But you also don't have all the litigation expenses. And sometimes we can use that money towards settlement. So if it's a factually simple case, people are coming in early. I see it a lot in the employment context. People want to give it a shot. Late mediation, a lot of people say, I want to come into the mediation after I know what my experts are saying or after discovery is completed. That's a good thing too. The benefit of that is that the parties usually evaluate the case more similarly. We have less of a gap in understanding. You also know what's going to be happening in trial. The negative of a late mediation is you have sunken costs already, right? So everybody's spent a lot of money. And when they're evaluating settlement, the plaintiff's saying, okay, I want this for settlement and I'm going to add an extra X amount for money I spent, and defense is going to do the opposite. They're going to say, I want this for settlement, but I've already spent 100, so I'm going to subtract that. That makes it a bigger deal. So we got to keep in mind litigation costs do play a part in the timing of the mediation. Some lawyers think it's advantageous to go to mediation when they have a dispositive motion pending. That can be a beneficial pressure point, but sometimes the other side's like, well, I could win this, so I'm not going to behave like I would if I were to lose this motion. So just be aware we can use the timing in a way that's advantageous to our client, and there's benefits to all of that. Selection of a mediator, this is important too. If you have, look at who your client is and look at the other side as well. If the other side needs a judge, let's say it's a big CEO and they're not going to listen to a lawyer mediator, you might need a judge's evaluative opinion, and that would be a good selection of a mediator. If you need creative resolution, if you need certain communication skills, if it's highly emotional, if you have a fragile client, you might want a certain type of mediator as well. You might want a more empathetic, nurturing type of mediator. So think of who's going to have the most persuasive impact when you're determining your mediator. Some people pick with nuance of law. I'm going to say I mediate every day. It rarely does the settlement turn on the law. There's so many dynamics at play between the clients and the lawyers and cognitive biases, and the law matters, but usually it's not an area that you can't brief and a mediator's going to understand. So keep that in mind. I mean, there might be some areas, and if it's, maybe it's land use and you need somebody who knows how to navigate that system. But oftentimes the law isn't the particular sticking point. And then the other thing I say is do not hide the ball to the extent you don't have to. Now, I'm not saying reveal all your cards. You may have a big depo next week and you don't want the witness to be ready for this information. But for the most part, sometimes I get to mediation and the client or lawyer's like, I'm not giving free discovery. Well, we're using information to extract concessions and move them towards your evaluation of the case. So if you're not going to share your information, it's really hard for me to move. So if you're coming to mediation, you might want to make that commitment. I'm going to give it a go. I'm going to hold X, Y, and Z, but we're going to share our information. That puts me as a mediator in the best position to actually be able to get you a settlement. Okay, so I say exchange early. Yesterday I did a mediation. This plaintiff's counsel got this case so ready, gave defendant everything, and we settled like in 3 hours because the defendant just came in at $75,000 when they normally come in at $5,000. And was making big jumps the whole time. And we were able to get it settled quickly. They knew, she knew her exposure, she was worried, she had gotten the authority. That's the type of situation I think is best. Know about the other side. I always tell people, as much as you want to think about all your strengths, because that's what you're going to do in court, you're going to discount them and, highlight your positives. Know what the other side wants and needs. That way you can address it. So if you know the other side's in a money crunch. Maybe that's a thing we can use to your advantage in the negotiation. Know what types of verdicts, know what types of cases they're handling. A lot of lawyers do this already, they do their research. Know who needs to be at the mediation. Sometimes, like, they're just not bringing the right people or they're not taking it seriously. You as lawyers can make the mediation contingent on so-and-so showing up. But you can make it contingent that the other side comes in with $100,000. Or you can make it contingent on anything you need. You can talk to us mediators, we can help you with that. But you can ensure that the people you need to be there are there. If you are a plaintiff, you should know the collectability of the defendant and any insurance issues. So if there's coverage issues, we're going to need contribution from the individual. Can they do that? What would that look like? What's going to, if you go to trial, are you going to collect on a judgment? All of this matters. Inform us mediators, so we're talking to adjusters. When there's coverage issues, I like to just right off the bat get the adjuster and start talking to them. Welcome. So keep that in mind. Knowing that type of information is very important to settlement, and it gives you power. So I have somebody say, he's not collectible at all, he has nothing. And I go into the plaintiff and they say, oh, that's interesting, he owns 4 houses, he has a yacht, he has 12 luxury cars. So know that about your client. Know that about the other side. And know what is a gain. Really know what we can sell. Like maybe there's a creative resolution you think they take. That happens a lot in my business litigation disputes. There's something I can get other than money that would appease someone to help me bridge an impasse. And we'll get into that when we get a little bit more. Okay, preparing your clients. This is very, very important because clients oftentimes can be an obstacle to settle. So every mediation is different, but there's enough where clients are the obstacle that your preparation could be advantageous. One is your role. So some lawyers feel the need to fight in front of their clients to show their client how good they are. That is not so helpful in the mediation. And if you tell them that your role is going to be different today, I help you with this, I do it anyway, but that you're going to be you're going to actually evaluate the case, that's good, especially for plaintiff's counsel who've set high expectation or defense counsel who've set low ones. We want them to be considering new information and potentially moving during the mediation. So tell them what your role is going to be and how I'm going to be able to help them with that. Also, and this seems so silly, that you tell your client this is probably going to be the end of the dispute. So some people have been living with the dispute for years. They're not ready to give it up. And they're saying, wait, what? Wait, I got to think about it. No, I don't. They're not ready. The thought of not continuing is a big loss in their lives. So I always say, get your client ready to settle. Especially those clients who are like not busy and dedicating all their energy to the lawsuit, and this happens. So we got to make sure they're ready to settle. The process. Sometimes I'll come in and we're at these insult numbers, these anchoring numbers, and the client gets so upset. They don't realize this is part of the dance. Get them ready for that. Also, money spent is money spent. It's sunken cost bias. People have a lot of trouble with that. So if you can talk about that, get them forward thinking rather than, feeling bad about the money they've already spent. That could be very helpful as well. Who needs to be there? So sometimes your client, and I don't know if you're plaintiff lawyers or defense lawyers, plaintiffs sometimes need like a support person. An elderly person may need a child. Some single person may need their best friend, neighbor. Somebody may need their dad who's a lawyer to give them advice. I think if somebody sued me personally, I'd want my husband there, some spouses. Make sure they have who they need. These are big decisions, and people feel uncomfortable sometimes making them on their own. So get the right people, make sure the other side has the right people. That's a big thing. That's a big thing I'm looking at in my pre-mediation calls too, that we have the right people. The goals also, sometimes it's not just about money, They want something else. What are they looking for here? I think if you're asking your client that you're doing them a favor, they'll like you so much. You know, what do you really care? What can we do here today for you? How do we get you there? What role is your client going to have in the mediation? So sometimes I'm in a room and only the client talks, the lawyer never says a word. Sometimes the lawyer talks, the client never says a word. Even if I ask their client a specific question, I'll be like, what do you think about this? And the lawyer will say, she thinks this is an answer for her. Sometimes, and a lot of the times, and I think what's really helpful is the balance of the two, where the lawyer's talking the law and the positions that they'll be taking in the litigation and maybe even the narrative, but the client is talking about specifics of what happened and about their business or their employment or whatnot. Depending on the sophistication of your client is what role you want them to have. It is informal. You can always say to the mediator anyway if your client says something you don't want it to. Stacie, don't tell the other side, or ignore that she got it wrong. You know, it's not a big deal. But some people take it very seriously. I think, you know, all these things, it's things to think about as you're coming in. Not one of these is instrumental to success, but things to think about. Combative listening. So there's different types of listening. We all learn active listenings like verbal, yeah, tell me more, and eye contact and whatnot. Combative listening is where you like can't hear it and you're just defensive. Sometimes I walk into a room and I can't even get the whole sentence out before they're like, that's not true. I get it, right? Like if somebody's telling me something that I did that I know is not true, I'd want to jump up and say, that's not true. It's not beneficial. It's not beneficial because you gain so much information, lawyers do, about your case. So what I'm talking about, how I'm talking about it, when I'm talking about it, this matters. So it's so much more helpful for you if you let me say the whole arguments and you take notes. I want your pushback, so I'm going to open it up. I'm going to say, please tell me what wasn't true and what can we say in response to this. But I think the combative listening, you can, like, lawyers do it too. It's not just and I get it too. But if we can get that and just listen to what the mediator says, and then together with the mediator develop a pushback to the other side. That's going to be more helpful. So if you can get your client kind of prepared for that, that can be helpful. And then prepare for downtime. So when I'm not in your room, I'm still working for you in the other room because I'm trying to get the other side to understand your positions and I'm trying to get you information back. Sometimes clients are like with the stopwatch. She was in there for an hour and only in here for 10 minutes. It's just because sometimes I have 5 defendants. Sometimes, you know, I'm trying to convince them of your position. They need to look something up. So just get your client kind of comfortable with these types of dynamics. This is just get information about similar situations just because it has persuasive impact. So if I do a PI is one of the areas I do. And if you had a back surgery, what are these settling for? What are these verdicts looking like? Some firms will be like, Stacie was a lumpectomy. This is automatically $350,000 settlement value. And, you know, that's not how easy it is because liability matters and whatnot, but it can have persuasive impact if I could show the other side, look, they're going for $350 and this, and this. So if you have comps, it's helpful. If you have a piece of property that might need to be sold, let's know fair market value. Let's do some research on that. You can do it pretty quickly anyway on Zillow and Red something. Values of businesses. I do a lot of business division. What is this going for? What are similar businesses going for? Landlord tenant, you have some institutional landlords. What are they settling these cases out? Any other tenants with habitability issues? Leases, if we're gonna, sometimes with leases, breach a lease, we do extension of leases and raise the price and exchange for like longer lease terms. Let's know what comparable leases look like. Wage and hour, I do a lot of models, wage and hour for models. There's like a going rate on some of this, of what this looks like. Same with like a lot of these elder care wage and hours that I've been doing recently. So if it's persuasive, use these comps. It can be helpful. Okay, mindfulness about earlier settlement discussions. I think this is a really big deal because what happens is you try to settle this case without us. You have created a floor and a ceiling. So if you said, I'll take 300, and the defense says, I'll give you 100, you cannot start, well, you can start, but then you'll be accused of bad faith, higher than 300. This has created the new ceiling and expectation. So all the moves you make before you get to that 300 mark, you're not even going to count on the other side, and vice versa. And what happens is you might have offered 100 because that's a really good settlement number, and now you come to me and you say, look, I want to settle around 100, I'll go a little higher, but now I just have to start at the 100. So you've created these barriers to yourself in negotiation. You're not able to start at the polls and create the gain that you would normally do. So keep it in mind. If you know you're going to negotiate and try to settle, just maybe bring in a mediator early rather than trying to do it alone, because it creates it. Backward negotiation steps. So I always laugh about this when I teach every Tuesday night, and I tell my law students, like, I never heard the phrase good faith, bad faith until I started mediating. This is now a phrase I hear like almost every day. I'm here in good faith. That was not a good faith move. They're acting in bad faith. This is with backward negotiation steps or non-productive moves or not generous. You can move backwards if something's happened. Like sometimes they lose their star witness or dispositive motions in their favor. They got rid of punitive damage. Like obviously move backwards. You're now in a stronger position. Sometimes they do it because of attorney's fees. Well, both sides are incorrect. So we got to just be mindful of all of this as we are deciding what we're doing even before we get there and how to negotiate. Okay. Pros and cons to remote. So, all of you that are do you all mediate in here regularly? No? Yeah. Okay, so pros and cons. Now, remote is the main method of mediation, sadly. I'd say 90% of my practice, I get one a week max in person. It's very efficient for lawyers. I love it. And that's a really great thing. Another great thing with remote is we can have decision makers from around the world there. So I have like somebody in Thailand, the CEO is in my mediation where normally he may not be. I have adjusters from around the country there versus just having the field rep in the mediation, so I have some more authority there. This is a really great thing. We can do document exchange very easily. People used to come into the office with the boxes filled with documents, and we'd be Xeroxing and sending them over. Now you just send it over. All of that's great. People, sometimes it's beneficial. They're not stressed. They can be in the comfort of their home. If you're remote mediating, think about whether you'd rather have your client in your office so you can be working together. There's more of an investment of energy and time if you're doing that. If you are in a conference room, I would just say it's helpful to have everybody on their own screen. You can mute them, but just so I can see everyone. It's hard if I'm in the corner of a long conference table with 30 people. I can't even tell who's talking. So keep that type of thing in mind. Make sure with remote, this is the one thing that happens sometimes is I have a lawyer at his daughter's crew practice, and then she was in the car as he was driving with me in the Zoom mediation. Then he went and ran some errands, and he's on his phone in the grocery store. It's not good. I went to settlement. So lawyers, you should make sure the other side is showing up seriously if you are doing remote. That they'll be in an office, they'll be on a screen, and not moving all around the place. Okay, so if you're doing remote, keep that in mind. Make sure your client, if they're home, they can connect. I mean, once in a while, technology becomes the biggest obstacle to my settlement. It's like they keep falling out. They're backlit. So much is happening. You know, the distractions of dogs and pets and kids. I love it. It doesn't, you know, kind of lightens the mood if it's stressful. I get little babies a lot in my mediations. I love that. But let's keep that in mind if you're doing remote. Being in person, it's an investment of time and energy that makes it more likely to settle. They do tests, they do social science experiments also on the persuasive impact of in-person. So as a mediator, we're looking to persuade everyone to move toward each other in their evaluations of the case. I have more ability to do it in person. They've looked in the context of job interviews, and people get job interviews much more likely if they're doing an in-person job interview than if they are doing it remotely. It's because we had person-to-person contacts more persuasive. I just had a race car driver sue his crew, his mechanic, everyone. They all came to the office. I don't know if we would have been able to settle it without, but it was so nice. They all hugged at the end. And they're going to be looking together in the future. Like those moments you really miss on the boat. We also, you know, I can block the elevator. No, I'm just kidding. But people don't, you know, it's so easy to just slam down your laptop screen and leave if you didn't like someone, like something that was said. So there's eye contact issues with remote. I don't notice that. That's not a problem for me, but I've heard other mediators complain about that. Just so make sure your client is showing up in a real way, that you're all investing energy, and that the other side is. So if I were spending my client's money and my time, I would make sure the other, you know, and have a conversation with the opposing counsel about this and set some conditions to it. Okay, speaking with your mediator, very important before the mediation. So I always do a pre-mediation phone call. Not to hear the lawyer tell me exactly what's in their brief, because I'm reading that, but to tell me any tricky dynamics, any obstacles or paths to settlement, what's happening in court, what's your relationship like with your client, what's your relationship like with the other side, anything I need to know about your client. So if you say, don't look at my, I had somebody say, don't look at my client in the eyes. Okay, well that's good to know. Or don't pull me out of the room because my client doesn't trust me. Good to know. Help me, my client's in the sky. I had initially told them I thought I could get him $1 million, but discovery's looking really bad for us. Get me out of this case, help me get my client in. Great to know. I know I have an ally in the lawyer. We can set up a system of communication without the client knowing. All of this is so helpful. If the other, you know something about the other lawyer, about the dynamic between the client, all very helpful. So sometimes you're saying to me, get me documents, I can't do this unless I see the medical records, I can't get to their numbers. Great, I'll call them. Or sometimes somebody will say, we need pennies on the dollar, this company's going under. I say, okay, have you given them your tax returns? Have you given them your P&Ls? Let's get them the documents so I can, they're not gonna just believe you on this. So all of this, talk to your mediator about. You don't need to just talk to your mediator about your position. We're seeing that. These other things are much more important, okay? Uh-oh, I heard a little beep in this, and I've lost it, but don't worry. Okay, sharing your mediation brief. Every mediator I've ever met wants you to share your mediation brief. Why? Because decision makers aren't in the room a lot of times. You may have a friend who's a lawyer that you want to take a look. If you're an adjuster in insurance, you're going to have a round table and come in with authority. Why not have them see your best arguments so they come in with more authority? If you're on the defense, let the plaintiff start working on their client and bring them down because you have great arguments. Now, you don't have to give them everything you give to us mediators. You could give them a whole different brief. You know, you may not want to talk about settlement and whatnot that you might put in your brief to us. I get it, but if you give them something, you enhance, I believe you enhance your presence. First of all, you speed it up. Something that would settle at 4 in the afternoon could settle at noon because they've heard these arguments. Second, if somebody is hearing an argument for the first time from me, and you're in this litigation already, they're going to discount it. They are not going to give it a ton of weight. If you've laid it out for them before, and now I'm jumping on it and talking nuance about it, it's going to be a lot more persuasive. So keep that in mind. Some people say, I'm not sharing less they do. I think if they don't share and you do, you're in a more powerful negotiating position. Because your goal is to get them to see the case like you do. And that's how you do it. You give them everything so that they can see the case like you do. If briefs, sometimes people give me a 100-page brief or just their summary general. That's so not helpful. That's just, because sometimes at 5 parties, you know, try to do it in 10 to 15 pages. your brief, and then if you're gonna have attachment exhibits, which everybody typically does, giving me a 100-page lease isn't gonna be that helpful. But if you highlight the portion, or the depot testimony, give me the depot questions surrounding it and highlight the important part, all of that's very beneficial. So just make it easy on us. We've got a lot to read. So for me, like for example, I have a mediation every day. So if I read everything way in advance, I wouldn't remember. I wouldn't remember who has a trial date, who doesn't, so I read at 5, I wake up at 5 in the morning to read briefs. So that way it's fresh and I'm focused fully on your case. So you want to get it to the mediator in a package where they can read it and consider it and make use of it. Play nice with opposing counsel. So this seems so obvious, probably a silly slide to have. There is a guy named Robert Cialdini who wrote a book called Science of Influence. And he looked at how do we get people to give us what we want. Okay, so that's what you're trying to do. Get an opposing counsel to give you what you want. How do you do that? You are, one of the primary things he talks about is likability. So they studied it with Tupperware saleswomen, and the ones that were most successful were the ones where the customers liked them the best. And they were breaking in the dough. Here, it's the same type of concept. If the other side likes you, they're going to be more inclined to give you what they want. So I have lawyers oftentimes hating each other, coming in, fighting. And then one lawyer's like, I don't trust that person. If they're saying this, it's not true. And I don't want them to get the contingency fee. Like they're actually mad. So you got to think, the clients already don't like each other because they're in litigation, right? So us lawyers, we can neutralize some of that if we're respectful with the other side. I've had a lawyer once say, the plaintiff's counsel, he's really smart, he's a great, nice guy. If he's saying settlement value is at $800,000, I think we should take it. It's like, oh, that is such a strong impact of playing nice with opposing counsel. So I see, variations and gradations of this. If you can get along with opposing counsel, I would just say it's a great idea. Get caught if you're about to go into litigation and an extensive litigation, grab coffee with them, or give them discovery extensions if you can. Just try to make it as nice as you can. Okay, mediation day. So that's all prep. Any questions from anybody about prep? I know we spent a little time on this.
Stacie, when you have one side or the other asking, let's have an our law firm in San Francisco. I'm the plaintiff's attorney, but we'll donate a conference room, and we have anything anybody needs. And it's on the BART line, you can take transit right in. But the defendant, he's, let's say, in another city nearby, but he thinks he doesn't want to be on the plaintiff's turf.
Yeah.
Does that come up?
Yeah, I do see this where people don't want to go to they think there's some advantage on being on plaintiff's turf. I don't see what it would be, what the advantage would be. If there's some power dynamic there, I've heard that before. What we do a lot is these hybrid mediations where some people are in the office and some are not. This is working very well. So I a couple months ago had one with the sheriff department of a county versus 4 of the surrounding cities. And it was about law enforcement contracts. There were hundreds of people in the mediation. And a lot were in conference rooms on screens, and I had some in person. I had a lot in person. We can do these types of dynamics, especially like ADR services. We have conference room, we're all set up for this. So a lot of my mediations do hybrid, or I have one party in the office, one group in the office, one group not. I don't know, with you specifically, with the plaintiff counsel having an advantage in hosting it. I've heard people worried about this. I would say let plaintiff host it, and then maybe they'll give you more because they're happy you came to their office. Yeah. It's like the trade-off. Maybe they'll give you more in settlement. But yeah, I've heard these types of comments before. I don't notice a difference.
When I do Zoom mediations, I had one, there was 350 people there. from all over the country. And so when I had a laptop, and the pictures were the tip of your little finger. They were just little teeny pictures. I couldn't even find myself on them. I mean, it did go well, but I just wanted to say that's really cool. That you can't really see anybody. I mean, you see the picture, but they're really teeny things.
Yeah, I mean, look, the more you have, it's harder. You bring up the point that one reason remote mediation tends to be good, because you don't usually have 350 people, is we get nonverbal communication. So I get chest up. 90% of all communication is nonverbal. So I'm getting chest up communication. This is very advantageous to me, because I can watch how everybody's reacting. Only, so much is in their facial expressions to what I'm saying, and I'll throw out a number, and then if they're not going crazy on it, I might be, that number might stick. Or if they're outraged and their eyes pop out of their head, I know, okay, that's not anywhere they're settling. But we get that. So the 350 people would make it hard, and that would be a challenge in and of itself.
Yeah,
see, at ADR services, they have big screens, so we can see everybody that's up there. All right.
Question?
Yeah.
Are you going to talk about mandatory mediation provisions at all?
I wasn't going to, but I can. Do you have a specific question?
Well, just what do you think about that? How do you deal with it when you get it's mandatory?
Yeah.
And one side doesn't want to be there.
Yeah. Well, it's interesting because my career started working in the court for a bunch of judges, and every day they forced them to come to me. It was essentially a settlement conference, but it was a mandatory mediation because I'm not a judge. It is hard to get the buy-in. But I'd have things, you're here, you're stuck for 3 hours, let's give it a try. Whether I think they should, I don't think there's any problem in having it, because all they have to do is say, I don't have any money today. I'll consider what the other side's saying. So I don't see the downside to it, and I see that we can get cases settled. The courts are really overburdened right now, so because of my connection at Straus, I'm helping one of the local courts. I'm trying to set up a program because I do a lot of trainings for new mediators who are dying for mediations. And so I'm trying to work with the courts to send mandatory settlement conference mediations to them. The courts are doing it because they need help. They need to get rid of a lot of these cases, and a lot of them should settle. So they're doing it. From a mediator perspective, it's more challenging. I love the mediator who works out of Hawaii. There's one who everybody has to fly to Hawaii. I'm like, oh, golden, I'm sure he settles everything, because if they're invested in going all the way to Hawaii, they're gonna settle, right? And so versus a mandatory mediation where they're just sending you people who don't really want to be there, then it's really challenging to get the buy-in. So it's really getting the commitment and the buy-in. They're more reluctant to exchange information.
Yeah. In addition to that as well.
Yeah.
Something I've seen some mutual super mediators do is they'll offer, they realize that they're there because they have to be there and they have to tick off the box. And they'll try to achieve as much as they can during that process. But to the extent they can't get it settled, and more likely that they won't be able to, they offer an opportunity for them to come back for another session, so credit for a future session. So once they're at a point where at some point they will be ready for mediation and it makes sense for them to come back in, they're going to be able to use this mediator in the future for a future session. And in the meantime, the mediator can suggest things that they can do to get closer to settlement.
Yeah, and we're going to actually talk about some of that, like what you can do if you don't settle. But I'm just glad I'm not in that situation where I don't get, I'm a private mediator now, so it's rare that they're forced to be, I don't see that anymore, but my early career was all that. I had my spiel on how to try to get them to just buy into the process. So it's a tougher experience. Why do you get forced to mandatory?
It's just contractual things.
Mm.
Where
oh yeah, in the contract before you, if you want attorney's fees, or if you want to go to arbitration. Yeah, I get that more often, and there's less buy-in. There's less buy-in, but I can usually do it. You got to get them convinced it can work for them to actually show up. Yeah, where they say you have to mediate to get the attorney's fees, so they just come for like a 3 or 4 hour. But again, we can get you set up, so even if it doesn't work then, we'll get you.
I have a question about, you're thinking about the negative, what did you call it, backward moving. I remember how that used to drive me absolutely crazy when I was practicing. Now I'm a mediator pretty much full time. And the thing I'm finding, and I, for some reason, I get lots of cases, I guess, because I did this stuff in court with a lot of pro-per, both plaintiffs and defendants. And those are the folks that it's just, I mean, lawyers kind of understand it, and they'll still sometimes move the opposite way, or they have their reasons. But trying to explain to them why, if you talked about a number before, and now you're coming in here, and now you're changing that number, or sometimes they put these outrageous amounts in their complaint, and they just tell me, oh, that's because I want to get, a certain amount of money, so I think I have to put that. I'm having a hard time explaining to them why that's so counterproductive in the course of settlement, because we end up, they've given a number, and we're like, well, that's the number I gave the lawyer before I sued, or right after I first sued.
That's what happens.
And they don't even have attorney's fees because they're pro-per most of the time.
Right.
But they have all these sort of emotional reasons why now I'm going to this bigger number, and this is where I'm just gonna stick for now, and I want you. And so then if they insist that I carry that to the other side, it's just, it's like now we've gone, now we've got another 2 hours of time to just get back to where you were.
Yeah. I mean, so there's things
to people.
So there's things as a mediator you can do in this scenario when I do these trainings that I talk about. So there's ways to get them to attach it to numbers and damages that allows you to get them to reconsider, asking them how the other side would respond to it and what you think will happen as a result of it. So you play out that scenario with them. What is going to happen when they do that is they're going to create a negative pattern of negotiation where the other side's going to then go backwards. And what's going to happen is now we're going to have a huge gap. We're going to talk a little bit about that. But that we can talk even more from just like mediator tools we can use in that scenario. Okay, so anchoring number lawyers, most lawyers know about this. The reason we call it anchoring is there's an anchoring cognitive bias, and Cialdini, the same guy was talking about persuasion, talks about it. People look at numbers and the reasonableness of a number in relation to an earlier number given. So if I say sweater, $200, okay, on sale for $100, you are more inclined to buy it than if I just say the sweater's $100. That's because it looks darn good if it's on sale. So stores know this, and they'll put like expensive items next to best-selling items and put it on sale, call it a sale even though that was the price point initially. That's because we're so influenced by it. It's so strong that it's a cognitive bias. Lawyers know this. Lawyers don't necessarily know the reason, but they know if I create a high number, I'm going to set an expectation. So if I want to settle for $350,000, I'm going to start at $1 million. Some say I'm going to start at $2 million for $350,000, but just say they're not that outrageous, and they start at $1 million. And that way, by the time I get to $350,000, the other side's going to be like, wow, look at all this gain I made. This is a great deal, okay? The other side is going to do the opposite. They're going to say, I'm going to start at $5. I want a message that this is a 5-figure case. I'm going to start at $5,000. And I'm going to then, if I come to $100,000 or $200,000, they're going to be like, yes, look what we got. Okay, so this is creating this expectation, okay? This is a good thing for you lawyers to a large extent. Because what you're doing is you're telling them essentially where you're going to want to be, and then you're going to create a situation where they feel a gain, okay? That's good. However, if you're so extreme, the other side's going to respond and be so extreme, and you are going to enter into this negative negotiation pattern. Is that good? No. Because you're trying to get the most you can for your client. Your goal is to get generosity from the other side, right? So you want to tap into that. So what you really want to do is you want to find the sweet spot. You want to be high enough or low enough, depending what side you're on, that you allow for concessions and you create that feeling of a gain because you've moved enough, but not so much that you're insulting the other side. Okay, that's where you want to be. Do cases settle at the midpoint of these insulting anchors? No, nowhere near it. And I could use every single mediation as proof to you of this. They settle at the midpoint when you start talking reasonable numbers. So we have to be very mindful of how we're coming in these situations. We want to be high or low enough to create the anchor, but not so much to insult. Why? Because there's this thing called rule of reciprocity. And this is another Cialdini concept where people respond to generosity in kind. So if somebody invites you to their dinner party, you're going to invite them back, or you're going to bring them a hostess gift, or whatever. This is the same. If somebody's generous with you, you're going to be generous back. That's why, so in mediations, I'm always talking about, look how generous this move was. Let's repay them. Let's reward them for this. Keep that in mind. So we want to create an anchor, but we need to be reasonable with it. Otherwise, the other day I was at 1,005,000. And then the plaintiff wasn't happy at 5,000 and said, they only gave 5,000, I'm insulted, 995. And then the 5,000 says, 995, that's ridiculous, I'll give 7,500. Okay, this is not productive. I'm going to continue this agenda. It happened this week, so I can continue this as my example. But that's not going to be productive. It would be 5 in the morning, and we still wouldn't be settled if we continued along this path. So we can't do that. That's not helpful. You're not going to settle. If you're giving an outrage, I had settled a dog bite case for $60,000. She started at $2.5 million. Not a good starting number. I always celebrate, so it worked, but I was like, giving these large, untethered numbers, not a good strategy. If you're going to give a large number, give us the reasons. Give us mediators like, okay, well, my meds are this, or my lost income is this, or, whatever it may be in your scenario. Okay. So after you give your anchoring number, we're going to be trying to get concessions. And your mediator's coming to you to try to get you to move, right? So be mindful, how you make your concession sends us a message, sends the other side a message, we're all reading it. So be mindful, you don't want to do huge jumps, because what is that going to convey? Or maybe you do want to do huge jumps to convey some message. I think you're better off coming in at a reasonable number at smaller measured jumps. People usually see like huge jumps and then smaller moves and then tiny moves. That shows like a slowing down pattern. So keep that in mind, what you're showing with all that. I say be flexible as attorneys. We do this every day. So I know what negotiation strategies are working and not working, when to turn it up. When it's the negotiations becoming stale, how we can spice it, what we could add. Follow, I assume all mediators know this, follow your mediator's lead when they're talking to you. I never change process without talking to you lawyers about it, but work with us, we're teammates in all of this. Never give a concession without getting one in return. So sometimes I get to a room and they say, I don't like what the other side did, I'm not moving. Tell them to give me a better number. No lawyer does that. No lawyer's going to give another number because you didn't like it. So I'll say, well, you got to give them something. I'll message you didn't like their move, but you got to give them something back, or they're not going to negotiate against themselves. So don't negotiate against yourself. Accompanying requests with information. So I do this naturally for people who mediate with me, because I know that when we explain why somebody should give us something, you're more inclined to give it. So if I'm telling you another point the other side made, or another potential risk you have if you continue in the litigation, that's the time I ask for a concession. So I hold information, but if you don't know your mediator, you don't know if your mediator is holding, don't give them 100 reasons why you win. Because guess what? The other side would say, I picked the weakest, I'll respond to that. Right? You want to peter out information. Save concessions till the end. We're going to really push on you at the end of this to make concessions. So save some movement. I always say stop short. I even tell people in mediation, stop short of where you're really willing to go, because the other side will feel a gain at the end. right? So if you say I'm done at 150, but you're really willing to go to 180, that extra 30 at the end, they're gonna be like, yes, I got the extra 30. Okay, so you gotta save some of this for the very end. We talked about backward step. All right, let's keep going. Mediator communication. So have us work with you. I would say I'm working for you today. So whatever you want me to say to the other side, I'm going to say it. Whatever you want me not to say, I'm not going to say it. How you want me to communicate, I'll do. So get the most out of us in that way. Make us your partner. Again, we're doing this every day. So what are we seeing? What are we reading in the other side? What is the emotional temperature? Those types of things can be very insightful. What would you do? Where do you, mediator, think the strengths are? Where do you think we have some issues? You know, a lot of lawyers ask me these types of questions. I think it can be helpful because if you have a jury, I would be a jury. What am I responding to? What do I like? What do I think of the clients and the participants? So use us for that. Make sure we know the issues. So you don't want the end of the day to come and now you've got to tell us something and the other side's not going to give it. Truth is, if you get the big issues out of the way, like the money, and everybody's happy with that, the littler things will never really work out. So, but just strategize with us. And should we bring it up now? Should we bring it up later? I'll say, let's hold this for right now. I'll just kind of gently talk about it and see if there's any issue. If there's an issue, we'll jump into it. If not, let's hold it till the end. So just be honest and open with us about all that. Talk to your mediator alone. Check in with them at some point. So in Zoom, that's really easy to do because we have cell phones. And you can text and say, text, Stacie, talk to me before you come back into the room. Okay, and then you can just go dark and talk to me without your client even knowing. Let us know, like, what's your client having fun? And they're not going to be having fun, but how are they reacting to me? What is resonating, what is not? Are you pushing back for your client's sake, or do you really think this is the value? Where do you think you can get your client to? These conversations with lawyers are so helpful. I always need to pull them out at some point. Because it gives me a sense where the lawyers, what the clients do, we can have frank conversations about things. So if your mediator doesn't do it, I think you should at some point ask to talk to them alone. Good pressure points, like give it to us. Give us all your good pressure points. Sometimes it's risks and costs. Sometimes attorney's fees are recoverable. Sometimes it's the comp verdicts. Give it to us so that we can use it. We're trying to help you. An insurance company said the other day, they were talking about numbers and she's like, I'm scared to give it to you. And I'm like, well, I'm going to try to get you what you want too. It's not just about what one side wants. I'm trying to figure out how to get everybody what they want. Like, give me the sense here. Keep that in mind. We are reframing. If your client's going to go off the rails, it doesn't matter. I'm not going to tell the other side your client did that. I'm going to reframe it into a nice little bundle, so it's productive. So they'll be like, they must be. I did a domestic abuse case yesterday. He broke. She claims, he disputes that they had several. It was a boyfriend girlfriend, several violent encounters. Where she was almost drowned and he dragged her. But on this one occasion, this last occasion, he broke her wrist. She had to get major wrist surgery. The muscle had come off of the bone and no one witnessed, like he couldn't get out of that one. When we were we settled for I think it was like $150,000. And when I went in a room, she's like, is he yelling about me? What's he saying? I said, no. He actually was very calm. And he's not talking, and he looks very remorseful, like he seems really sad in there. That changed, and that was true, and it changed everything. She dropped a ton. I was like, oh. This is probably so complicated because it involves domestic abuse, but certain things that I don't even know would be so, and they ask me a question and it means everything. Or a lawyer will tell me, you know what really got, after we settled, they'll say, Stacie, you know why I really did it? Was because you had brought up X. And I didn't know that would be the most impactful thing. So I bring up everything and share everything in hopes that something can hit. Lying, yeah, I did an hour-long CLA and CLE presentation. A mediator from JAMS asked me to do it about lying. And we spoke for an hour about the topic of lying in and of itself. I'm gonna say, I think everybody's kind of lying to me. I don't really care. It's because I'm not the decision maker. I love it. Go ahead, lie to the jury, see if they believe you. I gotta, if you're lying to me, I go to the other side and I'm like, there, he's lying. Look at the email. All right, I don't care. And in negotiation, I think it's actually kind of smart to call it white lie, mislead, spin. If you're telling a mediator, yeah, this is my bottom line, that's not going to be so great because then you're going to get your bottom line best case scenario. Like, you might as well make your bottom line higher. So, lying, I'm not so concerned about. I don't know if other mediators, it's like, I don't lie, like in my personal life, just so you know. So, I just expect everyone's kind of position. Do not agree to the mediator. Okay. Look, sometimes I'll come in and I'll be like, your client's in jail. Aren't you worried about that? Your trial's next week. Like, what are you going to do? How are you going to explain your client's not even there? I'm not worried. The lawyer will go, I'm not worried. Or they'll lose their star witness. Or this guy claimed last week that he had title to property. Even though the title's in somebody else's name, there's no written conveyance. There'd be no reason, there was no reason he would give it. And he's like, well, he just did. And I said, well, are you worried about the statute of frauds? Are you worried there's no writing? And the lawyer said, I'm very worried. Okay. Now, he should be very worried. This is not a good case. So I appreciate him saying he's very worried, but now I know I've got him moving. I've got him on his heels. He should get out of this case. Other lawyers will say, yeah, I'll say, did you see the email where she admitted it? And they're like, I'm not worried. I think it's a better strategy to not be worried, because when I know you're worried, that's my push. If I don't think you're worried, then it's not going to be such a highlight. I'll say to the other side, he's not worried. He thinks that it's consistent. So I tell lawyers, I wouldn't tell the mediator how worried you are about signing. That would just be, I like it as a mediator, but I think you do better for your client if you don't. Yeah.
Sorry, I have a question.
Yes.
What do you do if you get a number from one side, they say, we'll give this amount of money. You convey that to the other side, and they say, yes, we'll take that. You come back and say they're gonna accept this, and they say, well, actually, we're not gonna give them that money. Has that ever happened to you?
Oh my gosh, I've been so upset.
That makes you look really bad to the other side.
Oh my gosh, it's never happened to me, and I would be really upset. Well, that's you can't do that. Yeah, that's never happened, and I would try to hold them to it.
You say you can't do it,
well,
or you shouldn't do it?
Why? What would be the?
No, I know that it would be totally wrong, but I'm saying.
I think ethically as a lawyer you can't do it. You shouldn't do it. Well, you shouldn't. I guess you can do it.
Could be the client.
So they're going to say, Stacie, if you get me 150, I'm going to take it. Is this what it looks like? And then I go in there and I say, great news, I got 150, we're settled. And they say, well, actually, I thought about it, I want 170.
Or they may say, we never said that. They say, we never told you 150.
I've never had this happen.
Somebody was complaining to me about it recently, so that's why I bring it up.
Yeah, I would, have you done that? Have you seen this or done this?
No, I haven't. I'm just curious if
I've never had this, and I've done like that. I've never had that happen, but I'm like, Chris, so if I get 150, you are gonna take it. I'm like, put it in blood. No, I don't do that, but I would be very upset because my word as a mediator then is lost. Their ability to settle, I would think, would be lost. I'd be very apologetic to the other side and saying, they told me this, they changed their mind. I don't know what happened in the interim, what do you want to do about it? Yeah, I'd be upset. I would be really upset. Yeah.
I've seen this happen when lawyers are involved only, when they don't actually, it's like they put off signing the agreement until a later date. So at the end of the long mediation, you know, 8 o'clock, 10 o'clock at night, like we're gonna, but then there's these, especially when properties are involved and they have to do all, yeah, and then they have that like buyer's remorse or seller's remorse.
Yeah,
and then they
get
can't go back on.
this is why you got
even though they've agreed, and then there's like a whole bunch more negotiation, or sometimes they actually, I remember when we actually went to court to enforce this, you know, that the mediator had written down.
We're going to talk about this. This happened 2 days ago with a real estate company. He goes, we get to an agreement. He says, I need a few days. I said, no. We cannot take a few days. We need to sign now. I said, why do you need a few days? And he's like, well, we got to, we either have a deal or we don't have a deal. Like, if you sleep on it, bad things happen. Bad things happen. We need it signed. We need it signed. Okay.
Question, one more thing. I think lying is too strong a word. I think puffing is a better word.
Puffing, I like it better too.
Because, you know, you could say this is the best, the salesman said this is the best TV that has ever been made, you know, and that's okay, you know, I mean, even if it isn't, you know. And I think the same thing kind of goes with, you know,
especially negotiation, like lying about, so lying's a tricky word also because somebody's perspective could be different than someone else and neither could be lying. There could be a miscommunication, there could be a different way of looking at it. But in negotiation, it's puffery, I agree. That's why I don't take it so seriously. If somebody says I'm taking 150 and then when I come in with 150, they don't take it, that's would be a whole different ballgame. Like I think ethical ballgame too. Yeah, I like puffing better. Good point. Okay, revealing your bottom line to the mediator. Should you come in and say, Stacie, I've worked with you 10 times, look, to be quite honest, I'll go to 75,000 today. You shouldn't. You shouldn't do that. Why? Because I heard it. And now I know that's a settlement number. I might have been able to get you 40. I could still try to get you 40, but I know I'm looking for overlapping interests. I'm looking for zones of settlement. Like, it's just less likely. So what I would do if I were a lawyer, and I have gotten people lower than what they told me they would go up to, but then it's like, it's weird like from a neutral perspective too when I know it, because how, am I saving you the money? Am I letting them control the negotiation? It's just weird. So what I do think there is a time to tell me where you're going, but again, I wouldn't tell me real bottom line. I would puff. I would use puffery. And I would tell me where, you give me a sense, right? And we'll talk about this. Because if you tell them, I'm going to try to stretch you, I always think, and just from doing this every day, when somebody feels a stretch at the end, they are more inclined to take the deal. So I'm going to try to stretch you, so don't give real bottom line to your mediator. And you can just say, look, I want to, today I'm going to stop, or I want to stop at 500,000. Even if you're willing to give more, you could say I'll stop at 500, and then the mediators could say, well, what about, could you go to 550? I think I could get it at 550. Then you could give the 50 and everybody's happy. So just stop a little early. Okay, mediators, we use a bunch of tools. So in that example I gave you from the other day where one was at $1 million, then 995, then 990, and I had 5, and then I had 7,500 and 10,000. This is going nowhere, right? Like, if I keep on this path, it would be so annoying. This would not be productive. And both of them are like, I'm not, I said, you guys, come on, this is not productive. I gotta get one of you, make a productive move. No one would, I'm not gonna do it if they're not gonna do it. And look, Stacie, I see this as a 5-figure case. That's what the defense was telling me. By the way, case settled at 380. She saw this as a 5-figure case. She's telling me earlier, that's puffery. Puffery again. And I said, we gotta make this productive. This isn't gonna work. So let me give you some options. One is keep making your little micro moves. But in the background, give me a sense of where you can settle this case. Like, is this case settling at 200? Is this case settling at 300 or 400? Like, where are you in all of this? You could tell me behind the scenes. And then as you make your micro moves, I can start doing hypotheticals where nobody is locked into their number. And instead I'm doing, what if I could get defendant here? Well, I have no idea, but what if I could get him there? What if I could do this? And I'm testing the waters behind the scenes. A lot of cases settle that way for me, where I'm just dealing with real numbers without committing anyone, and they're all in their little $5,000 moves. Okay, that's when people don't want to be productive. Another choice they can do is brackets. Now, some lawyers hate brackets. It's too early for brackets. It's too late for brackets. They've got all these restrictions with brackets. It tends to be when I try to go to brackets, when they say no, we end up in the exact bracket I thought we should go to, but it's 3 hours have gone by. But they are worried about brackets. Now, brackets, the benefit of a bracket is it's a simultaneous jump. So when everyone's worried the other side's being unproductive, we together are productive. Why is that beneficial? One, you have the gain that you need to feel to want the deal. And two, you go into a reasonable settlement range. Cases settle when we're in a reasonable settlement range. They always do. And if they don't, they're going to settle when we're in the reasonable settlement range. So I'm making this into a reasonable settlement range rather than these insult unproductive numbers. Who gives brackets? I could give a bracket. I'm happy to get a reasonable bracket. But a lot of times you lawyers want to give brackets. Fine. Give a bracket. Let us start looking. Why is that beneficial? Because they're going to read the midpoint. And you're going to make your midpoint better than you're actually willing to go for your client. And they are going to see, oh, they gave me a $500,000 midpoint here. Okay, maybe we can settle this case. And then defense will come back and they'll give a $100,000 midpoint. So now I've got way closer. I'm between 1 and 5. And then if we go a few more rounds, I can get you even closer. And we could have a midpoint of 200 and a midpoint of 400. Now we're rocking and rolling. Okay? As a mediator, I can take your midpoints and make my own bracket out of it, or convince you to go to your midpoint as a hard number. Or I can start doing hypothetical and say, look, I see these midpoints. It's between 2 and 5 or 3 and 4. What about like 350? Can everybody jump in for 350? No, my client wants a 4 in front of it. Okay, could we jump in? What if I could get you 4? What if I got you 390? Is that close enough to 4? And I can start playing with numbers again itself. Okay? So brackets can be very helpful when you're at these ridiculous outer numbers. So talk to your mediator about that, and you can help them if they don't know how to use brackets, but hopefully they do. We can use an objective framework to settlement. So sometimes I did an insurance commission, so we were all working off the same numbers, although it was like the room could be filled with the pages of all these numbers. And they had like $1 million differential in what they thought commissions were due. Well, let's get a forensic accountant in here. Let's get some guidance. And maybe we'll be bound by the forensic. Maybe they'll make a report to me and I become a decision maker. Maybe we have a second session when we get the forensic analysis. And we agree, I can set up a whole framework for how we agree on this third-party neutral. I also do it with like real estate appraising. If we're selling property, we can use real estate agents. We can do it with repairs of construction defect cases. We often do it. We get a third party that everyone agrees on. So we can set up a framework here where we can't get everyone to see the case similarly. And then lastly, mediator proposal. I think everybody knows those. Remember, it's settlement value that we're picking, so posture your mediator for a settlement. I always say, look, you got to like make it for your mediator a number the other side could actually take. So if you're trying to work your mediator at 500,000 and your mediator says, I can never get the defendant to 500,000, that's not good because it won't get accepted. So I'll say, look, I got to get this in the 4s somewhere, and if I'm up too high, I'm going to lose this person. If I'm down too low, I'm going to lose this person. And I try to get a sense from everybody what could be a successful. Almost every mediator's proposal I've ever done is taken, but I never give them unless they're wanted. I met a mediator who gives them even when you guys don't want them, but I don't think that that's good because it can mess up your case. So mediator proposal, if your mediator isn't automatically giving one, talk to them about it. There's times when it's not going to be helpful. It's typically helpful when decision makers are outside the room.
Question?
Yeah.
With regard to the mediator proposal, I mean, you consider where the case might ultimately go, I mean, versus what might settle the case? In other words, evaluating the case, sort of? No,
it really should be settlement value because I'm not helping you if I'm telling you where the case may go. And you never know, right? Like, you never really know. In a jury, it's strangers. You get a sense. Like, on the statute of frauds case, I'm pretty sure there's a winner on the title. but it's most of the time you don't know. So the most value we have is by getting settlement value. You're here to settle the case. How are we going to get it settled? This number actually could settle it if everybody just goes home and stretches a little more. And so, yeah, I don't think that the end result is as helpful. But oftentimes, end result, or what you, so if you think 90% chance I get this verdict, and 50%, 10% I get that verdict, that could inform your settlement evaluation of the case, and then that will inform my number, because you'll say, I'm not going to pay 4 on this one. I'm no way are they getting to 400,000. Or you see what I'm saying? So indirectly, yes, because it informs your settlement. Yeah.
The one time I sort of spontaneously did one was 2 parties. They were very much, it wasn't the money, it was the principle on both sides, and one was going to go to the Supreme Court with it. And they just, I was able to get both of them to say they would take or give a certain amount of money, but they refused to be the one. They didn't, neither one of them would be the one to be the first proposer of that. They just, I could not get either one.
Do it.
Yeah, so that was like,
That's when we do our hypothetical.
it just, I heard it coming out of my mouth, I'm like, oh no.
Well, it's not a proposal if it's in real time, so it would be like a hypothetical. What if I got them here, could you do it?
Right, but neither one of them would be the first one to go. Neither one of them would put it on the table.
Right, so it's just hypothetical.
Yeah.
For us. Yeah, and that's a great case. Oh, that's my situation. It sounds like that because you're in the what ifs. Okay, bridging impasse with creative. So one thing I've seen brilliantly for you negotiators out there, if you're offering money, and then the next round don't offer money, offer something creative, they assume you're done with the money. Like, I don't even say it, they just assume it. That's a great negotiating tactic. If I'm ever in a negotiation as a party, I'm doing this. I can't believe it works every single time. So that is something to consider. But we can bridge impasse with creative options. It can be, so when I'm thinking creative option, I'm thinking 2 things. One, I could trade off priority of interest. If you need something that's of high value to you and the other side doesn't care about it, great. We'll give that to you, and in exchange, you give them something of high value to them. Fantastic. Example, you want to sell widgets in Argentina because you want an exclusive distributorship and they don't care about Argentina as much. You take Argentina and they love Canada and you don't care, great. They take Canada, we traded our priority of interest, everybody's happy. This happens a lot. And by asking like mediator type of questions, like open-ended questions, we can figure out people's goals, and I can get everybody what they want and everyone's super happy, and we can get a little money and we can do some of these creative. We can also find mutual gains. So sometimes this litigation has created such disharmony in their community, socially, or even in their business community, and we can repair that way. So we could do joint press release, ribbon cutting ceremony, a party together, a future project, things like that where everybody feels the mutual gain. So there are ways that we can really create value in, for people that are non-monetary. So if somebody needs money immediately, okay, maybe it's like within days. If somebody needs a payment plan, they can't do it, that's something we can do. We can rewrite contracts. I'm always rewriting contracts. I had a television broadcasting system and the TV station. TV station says, whatever we do, this is the brief essentially, I'm open to suggestions, but I will not, I have 2 more years on this contract, I am staying with this broadcasting system. Television broadcaster, I need to get rid of this TV station. They're not paying me enough, I have someone else wants to take it over, they're not following the rules. I don't care what happens, I'm getting rid of this TV station. At 3 in the morning, we finished rewriting their whole contract where the TV station was paying more, they got an extra 2 years, they were gonna abide by all the rules. The TV station wanted it because they'd run these banners at the bottom all day long, selling their vitamins and all their products, and that's where their real revenue was. So we were doing revenue sharing with the broadcast, and you can be so creative in this stuff and get everybody what they want. So that's a great thing. Lawyers come in, even in like employment cases. Sometimes I can re-employ in a different facility or with a subsidiary company. there's always something. PI cases, there's less. Although I had one where they fell in one of these national retail stores, and as a sign of goodwill, they gave them a $1,000 gift certificate because it was the holidays. By the way, with timing and mediation, I forgot to tell you, besides early and late, there is a settlement season, kind of, and that's now. So right before the holidays, right before the end of the year, defendants want to clear their books, insurance companies want to get out all these stale cases off their books, plaintiffs want to take money, so it's in this tax season. It's a lot easier to settle. So get your cases in right now, you can get top dollar. It's kind of like, I need a new car, they're like, wait till Christmas to get your new car, like the end of the year. That's same with settlement. I think you could get better value on your settlement, and it's, right now, and I notice this every year, I'm like, oh, settlement season, we're here. Yeah.
I have a question on these non-monetary items. Do you find that it's more helpful to raise that issue early and get the parties thinking about it, have them have those, ahead of time, or for it to come up later and then everybody's like, oh, that's a cool thing I didn't think of. I mean, because I can see the positive for either. Like sometimes it's like, oh, that's something we never thought of, and what a great idea, and then they get excited about it at the end. Which one's better, or is it?
I start with, not start like first question, but I start asking about it at the beginning, and I continue, and I keep talking about it. So I do it throughout. Because there's a time where I'm going to then hit it harder, but I need them to start thinking, is there anything of anything that's of value to you that's not money? We can do anything. Like I had this
time. Tell the lawyers about that ahead of time.
I tell
find out from the client what things are important, like the apology or the handshake.
Apologies are tricky because an incomplete apology does more damage than good. So with apology, that could be, we could have an hour MCLE on apology, but I do bring it up right away. And I just say start thinking about it. That, maybe when I'm not in the room, you can consider it. I'm here to brainstorm. It depends on the case. Like some cases are really good. These business cases. I just did sheet metal fabrication, and this guy was working for the company and then started a competing business and decided to get up. That's right for creative. The plaintiff was going to get a percentage of the business for 3 years, and there was so much we could do in this industry. Some cases it's less obvious, but I'm exploring it all the time because it helps me get over, to bridge an impasse oftentimes, and people don't even know they want it. I had this guy invested in a gold coin business in Dubai and in a movie. We lost a ton of money, and our settlement involved the sale of Persian rugs and commissions. It had nothing to even do with it. There's so much we can work with. I threw up, did I do a chocolate chip cookie? There's so much we can do that I'm always thinking about it just in case.
The gift certificate sounds like a good.
The gift certificate, who would have, that's the only PI case I've ever had a creative. Do you have a question?
Have you had much luck with apologies?
Okay, so apologies, yes. So I had this guy fly out. It was a premises liability company. It was a big hotel chain, and this woman fell, and it wasn't marked well. They redid the whole entranceway of the hotel as a result. And the guy flew out to this woman and he said, can I go talk to her just right off the bat to start the mediation? And he said, I am so sorry this happened to you. Let me shake your hand. I want to make this right. We've changed it since, so this doesn't happen to someone else. She settled for way less than she had. She was like, Stacie, he's so nice. I'm like, I know. He really feels badly about this. She's like, yeah, I don't want to punish them. It's like, is it brilliant? This paid for the plane ticket and then. So an effective apology, very helpful. I've had other cases where this guy's dog got mauled by another dog, and he was so upset. He was crying the whole time, and the woman apologized, sincerely, I'm so sorry this happened. And he took significantly less. So yes, it is a great tool. But I'm sorry you're upset, not a good apology, I'm sorry this happened to you, but it's not my fault, not a good apology. So those can be harmful. So if that idea, and some of the plaintiffs said they never even got an apology, I would explore what that looked like. Hey, is there an apology you could give? What would it look like? I would coach it heavily. I would figure this out because you could do more. But a well-done apology is pretty good. Look, on the other side, even if I can communicate remorse, like in the domestic abuse case yesterday, it changes everything. It changes because they get rid of some of that like ego emotion, some of it, not all of it, that's not it. Okay. Confidentiality limitations. This too could be an hour in Celia, and it often is at ADR services. I've done an hour program on this. Keep in mind just the basics. This, when we say everything's confidential, you can share information, don't worry, the court, it means the court never hears, right? That's what, in a civil proceeding. It doesn't mean they can't take discovery. It doesn't mean they can't tell the media when they walk out of the mediation. It doesn't mean it's very protected at all. And when I do business lit cases and there's a fraud investigation pending at the same time, that's coming in. What I heard, it could come in if they knew it. I don't know if people really pay attention to this, but it could come in. It applies to other civil proceedings as well, but it really just means it's inadmissible into evidence in a civil proceeding. That's all it means. So if I tell lawyers this all the time, if you need it quiet, like I worked on that Michael Jackson case where the little boy sued Michael Jackson. This was like an ironclad confidentiality agreement, like a written contract. Nobody was going to say a word to the mediator or anyone, including within our office, of what was talked about in that mediation. Okay, that's what you got to do if you need to protect your clients. So I always say, we sell it to all of you, but you got to be careful. You got to be careful. And then now there's new evidentiary code sections where you got to reveal to your client that things in a mediation are confidential. Okay, never sleep on the deal. Never sleep on your deal. Seriously, I can't tell you how much I mean that. Do not do it. And it's not just me. Go ask any mediator who works right away. They're going to tell you the same. Okay, just some additional negotiation tips. When you make an offer, put a time component and expiration on it. Why? Because we know with scarcity effect, people want things in limited supply. Time is limited supply. That's why cases settle at the end of the day or right before trial when time pressure makes cases settle, makes your offer accepted. When I give a mediator's proposal, I always have a time component. It always expires. I mean, I find out how long the sides need, but then it expires after that. Contingency agreements, so the ifs. If you're worried about, yeah, I would take this, but I'm concerned about X, Y, and Z, that's okay. We'll get you, well, I can set up a contingency. So I had a case where a neighbor was infringing with their garage on the other neighbor's property. I have a lot of these ones actually, where they don't realize, and then because the gate's even in the wrong area, they're infringing. This guy was able to keep his garage up on the property and pay X amount to do so. But if there was an earthquake and the garage came down, he couldn't rebuild. She was so convinced there was an earthquake. I went home that night, I was like, honey, do we have earthquake insurance here? I think one's coming, because she was so concerned. So we just do an if. We do that all the time. Like, I'm worried he's not gonna pay. All right, let's put a stipulated judgment. There's so many, we do this all the time. So I can pretty much protect you from anything. The other day I just added in an indemnity because it was a landlord tenant and lots of there were 5 on the lease, but 9 people had lived there at some point. And the plaintiff was willing to indemnify should any of the other family members bring a lawsuit. Because the landlord's like, I can't enter it unless I know no one will ever sue me in relation to this property. So we can handle that for you. Use your power in the negotiation. If you have unlimited resources and they don't, that gives you power. If you're alternative, if you know you're winning the trial, liability is undisputed, That gives you power. Your alternative, your BATNA, your best alternative to a negotiated agreement is powerful, okay? So let's keep that all in mind. Argument dilution, don't do it. Give a couple reasons, not 100. They will focus on the weak ones. We talked about the more you explain, the more you get what you want. I told you stop before your full authority, so you can give a little at the end and they feel the stretch. If you're negotiating without one of us, acknowledge what the other side wants. So if they say, look, I want to work there for another year with the raise, and you would say, oh, I get that, I could see that. Let me see if I can get it. And then you come back and you say, here's the, I can't get you that, but I can get you this. That goes a very long way. That's that likability component. If you just say, yeah, whatever, I want this, then you're not going to get it. So mediators, we thank people when they make a concession. We do all this for you. So if you're not with a mediator, you've got to do it on your own. Okay, after the mediation, we got to think about what are we going to do. So we get to an agreement. Your best case, you have a long form agreement ready to go. You've already negotiated it with the lawyer on the other side before you got to the mediation, and all you're doing is plugging in numbers. That's your best case. Second, long form agreement, you haven't negotiated, but it's ready to go, and you can send it over to the other side in the next half hour. Third, short form agreement. So like ADR services, I have one, I send it out to the lawyers when we get close to settlement to start working on. This has all the key terms, waiving confidentiality. Oh, by the way, with confidentiality, I kind of skipped by that slide quickly. You need to make sure you waive confidentiality for the enforcement of the agreement. Always, because otherwise they can't even look at that, because everything written and said in the mediation is confidential. Okay, next, short form. Great, it has the key provisions. You could go home and do a long form, or you could just stick with our short form. It's really easy now because it's all digital, so you can just add in a few other provisions and call it a long form. Next is me confirming. So some people like mediator, they just put the terms in an email and we'll confirm it. I don't think this is great. I do it for people if they want. So I'll say, thank you for your hard work today. Please confirm. Congrats on reaching a settlement. Please confirm the settlement as follows. And I'll list it out and then I'll get a response, okay? Lots of lawyers like this. I don't know this stands up. I think it stands up in court, but I don't think it's great. It's not like a signed agreement or even a written offer and a written acceptance. But people like it. It potentially does. I could see how it could, but I think it's weaker. And the worst is like oral agreement, right? It's unsupported, because let me tell you, those fall through all the time. So oral's not good. Have your mediator stay in the mediation until everything's signed. I stay there, I make sure like everybody's on the same page. And now, if the lawyers get along, I'll have, when it's drafted, I'll have everybody take a look at it, and then if there's any changes, just bring everybody into a room, and we can do it in real time. So the lawyer that's doing the editing can put on the share screen, and everybody can work on it together. It saves a lot of time. But otherwise, we go back and forth, and I stick with them, and I talk about provisions and help them work it all out. Protect your client in the settlement agreement. So if your client is taking a payment plan, what are you going to do if they don't pay, right? So you want to have a stipulated judgment. A lot of people want that and they hold it. I would put in attorney's fees so that your client isn't burdened by having to go enforce the settlement agreement. Some people put liquidated damages. Some of them are enforceable, some are not. Some say, let's do a penalty of what I complained for, and that full amount, and then the payment plan is a discount on that, whether that upholds, I leave it up to the judge. If your client is paying on a payment plan, obviously make sure there's a cure period. I'd put myself, if I were the lawyer, in there too, so you get email notification of it. So I would require the cure to be twofold, because what if your client was flaky and didn't see it? So I help my client. But make sure you have a good cure period on that. If your client is having trouble paying each month because of the emotion of it, maybe set up for auto withdrawal from their bank. A lot of people do that because they just can't think about it or deal with it. So we can do it that way. You can hold it in your client trust and you can make the payments. There's ways we can do it. Use. Sorry. Okay, recitals. Do you use these in your settlement agreement? They're important. The reason they're important is because the court cannot look at oral communications. You're waiving confidentiality for enforcement of the agreement, so the court will only look at your settlement agreement. Okay? So let's say you take $100,000 because the defendant told you they have no insurance. And next week you find out, oh yes, they do have insurance. You would want to sue for like fraud in the inducement or something, because maybe this case was $1 million. Or maybe they had represented to you they had no money. Or maybe they represented, whatever may have induced you to taking a deal you might not have otherwise taken, you should need to put it into the recitals so that the court can look at it. Otherwise your client is not protected. There's nothing you can do. You can't prove fraud in the inducement like you would in a normal contract case. Okay, talk with if anything you're concerned about, talk with us. We know how to do this. We can get you, if it's indemnity or the contingencies, whatnot, talk to us about all that. And we'll help you come up with the language. Some lawyers think non-disparagement confidentiality is like pro forma. They don't even bring it up and they just throw it into the agreement. Others feel very strongly that they not have it. Companies tend to not want it, non-disparagement, because they can't they don't know if somebody in the lunchroom is going to badmouth somebody. So they're more restrictive, and then sometimes I usually can get past this by just binding certain officers or players in the mediation. What's our time?
It's 11:32.
Oh, we're done. Okay. When a case doesn't settle, it hasn't settled yet. That's what I always say. 95% of cases settle. I have a file on my desk right next to me. When you kick me out of the room of your mediation, I open my little file. Who should I call about today? I have them tell me right away. When should I circle back? What's happening? I'll set them up for discovery plans so we can have an effective second session. Maybe we're waiting for a dispositive motion. I always stick with you on it and continue to try to get it settled. Some days I settle 3 cases because 2 from last week and the 1 for the day. So keep the mediator involved, let us help you get settled. Don't do anything that's going to make the other side so agitated they don't want to settle. But I do think setting depots and letting them know the costs of litigation right off the bat after mediation can be helpful, because it is a reason people may work. And then lastly, good faith. So when people are disappointed and settle, you learn so much in these negotiations. You learn what the other side's talking about, how, why, and you can get your case really prepared for trial just from having participated in the mediation. So I really don't think it's a waste of time, because I think it helps with litigation, or it helps with the second session. Okay, thank you all. Thank you for having me. If you have any questions, you can always